In the last 20 years, 3 Supreme Court cases, Heller, McDonald, and Bruen, have shaped our modern understanding of the Second Amendment. But Bruen could be considered the most consequential. That's because it established a new framework for evaluating Second Amendment cases, replacing the commonly applied balancing test centered on public safety with a standard centered on constitutional text and historical tradition. Since the Bruen decision, lower courts have been inundated with challenges against a variety of firearm-related restrictions and prohibitions, and the inconsistent outcomes of those cases signal disagreement over how the new framework should be applied. A few post-Bruen Second Amendment challenges have made it to the Supreme Court, the most recent being United States v. Hemani. In this case, Mr. Hemani was prosecuted under a federal law that prohibited unlawful users of controlled substances from possessing a firearm. The government argued that historical laws restricting habitual drunkards provided the necessary analog to support Hemani's prosecution. The Supreme Court unanimously disagreed. While the government had shown a tradition of disarming dangerous people, Mr. Hemani was not alleged to be dangerous, violent, or intoxicated while possessing a firearm. Despite the 9-0 vote, the decision did little to resolve the broader questions that have lingered since Bruen. And until the Supreme Court provides further guidance, the legal community is left wrestling with a fundamental question: who can be deprived of a constitutional right? And what historical tradition is sufficient to justify that dispossession? Is the touchstone dangerousness, status, some combination of the two, or something else entirely? From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller. Today, we continue our conversation from Season 4, Episode 1, and dive into the recently released decision for United States v. Hemani. If you like what you hear in today's episode, visit go.osu.edu/drugsonthedocket to follow the series. Earlier this season, we brought on a couple of legal experts to help us unpack Hemani, one of the more closely watched Supreme Court cases dealing with drug policy and the Second Amendment. When we recorded that episode, the Supreme Court had just heard oral arguments, so we spent that conversation exploring competing theories about what the justices might do, whether the case could be resolved on statutory grounds, what role dangerousness, marijuana use, and constitutional history might ultimately play, if any. Now we have an opinion from the Supreme Court providing some answers, and as tends to be the case with your lot in legal education, you guys probably have some new questions as well. But before we get to the good stuff, Doug, please will you do the honor of welcoming back our guests?
Thank you so much, Hannah. Absolutely. I'm so excited to once again have Professors Joel Johnson and Jake Charles, both from the Pepperdine Caruso School of Law, with us. And I want to start by, I think, accurately stating they both predicted that Hemani would prevail in this case. And that actually is in sharp contrast to some of the other law podcasts where I heard people make contrary predictions. And so we've got clearly the two most astute observers of the court's work in this space, and so excited for that. And come at it with different perspectives. Joel's scholarship, for example, focuses on criminal law, criminal procedure, statutory interpretation, and constitutional law. Joel filed an amicus brief in the Hemani case arguing that the court could resolve without reaching the Second Amendment question by focusing instead on the vagueness of the criminal statute he was charged with and its unlawful user language. I'm looking forward to hearing your thoughts on what actually played out in Hemani, Joel. So thank you for joining us.
Thanks for having me again. It's a pleasure to be back on.
Wonderful. And we also have Jake as well. Jake's one of the nation's leading Second Amendment scholars. Jake's amicus brief approached the Hemani case from a somewhat different angle, arguing that history supports legislative authority to disarm certain categories of dangerous individuals and exploring how courts should evaluate those kinds of categorical judgments under the Supreme Court's modern Second Amendment framework. Jake, very excited to have you back. Welcome, welcome.
Thanks for having me.
So SCOTUS was asked to consider whether a federal law that bans unlawful users of a controlled substance from possessing a firearm is consistent with the Constitution's protection of gun rights under the Second Amendment. So you each submitted amici, as Doug already said, one for the respondent, one for the petitioner. Joel, yours focused on statutory interpretation. Jake, yours affirmed that this is a Second Amendment case, but you and your co-authors differentiated yourselves in some important ways. And again, both predicted Hemani victory, so well done. Was there anything about the vote or the majority opinion that surprised either of you?
The outcome didn't necessarily surprise me because we predicted that Hemani would win. I think, though, that I had said I thought the breakdown would be 6-3 or 7-2, although I didn't name any names. And so the 9-0 outcome, I guess, did surprise me or exceeded my expectations. I'd put a little bit of an asterisk on that 9-0 headline because the decision was unanimous, but it was unanimous only as to the bottom line, the judgment. The majority opinion actually only speaks for 7 justices. Justice Alito wrote separately, concurring in the judgment only, and he was joined by Justice Kagan, and they took a slightly narrower path than even the majority. I was trying to think of another instance where Alito and Kagan paired up on a concurring opinion. That's a rare pair. Who knew that it would take marijuana to bring them together?
Jake, you want to jump in?
I agree. The most surprising thing was the unanimity in ruling for Hemani in this case. I thought after oral argument that the government had probably 2 votes in the case. Some of that might be explained by the narrowness of the decision. Essentially, this ruling comes down to the government cannot disarm Ali Hemani based on the evidence it produced in this singular case, and not much more probably accounts for the fact that we have unanimity in result.
Joel, your brief urged the court to consider the ambiguity of the term unlawful user, avoid the Second Amendment altogether. I mean, obviously the court did not take that off-ramp. So what opportunities did the justices pass up by treating this as a Second Amendment case? Or put differently, what do you think the justices successfully sidestepped?
The biggest opportunity that, in my view, the court passed up here was a chance to say something that's actually portable to other cases and other contexts. My proposed statutory construction path essentially drew one clear line. The statute should be construed so that it reaches only those who are intoxicated while armed and no one else. And a decision along those lines would have settled what Section 922G3, the unlawful user statute, means for all 922G3 prosecutions, right? It's sort of a portable decision. And beyond that, if a decision along those lines were grounded in some clear rule of decision for construing criminal statutes, it could even have broader reach beyond that, right, to apply in other contexts. But the court's as-applied constitutional holding, which Jake just mentioned, it does neither of those things. It's tied to this one statute. It's also ad hoc in the sense that it is fact-bound, and it doesn't really announce a general principle. In fact, it doesn't even settle 922G3 itself. So after Hemani, we still can't say whether the government can prosecute someone who's high while possessing a firearm, or an addict, or a user whose habits differ just in degree from Hemani's. Each of those questions now has to be litigated case by case. And so that sort of vague phrase, unlawful user, it's still on the books, it's still undefined, and it's still available for prosecutors. I sort of took the opinion as a message to prosecutors, build better records and try again. The statutory argument, though, is still available, right? So in these cases that are already being litigated in the lower courts, that statutory argument that I made in the amicus brief may be useful to defendants, I think particularly non-marijuana defendants, because so much of the opinion here was focused on marijuana. It may be nice to focus on the statute more for other drugs.
Is it ultimately that, say, we have somebody who's a regular cocaine user or a regular meth user, but who has his firearm safely locked up or using it in other ways that don't seem to be connected at all to misusing this otherwise illegal drug? Is there argument in the future, well, this is just a vague term, and so you strike down this as a vague term, or is it more the Second Amendment problem, and if given its full reach, risks running into the Hemani problem?
Yeah, I think both arguments could and probably will be raised, right? To just sort of strike the statute as unconstitutionally vague, or also to read it narrowly, and you could point to Hemani as some evidence for why you should do that for an avoidance reason, as you said. But I also think just generally, when it comes to federal criminal statutes, when any vagueness issue is raised, that kind of the default is just a narrow construction. There's usually some core that can be sort of retained without striking the entire statute.
And Justice Gorsuch's opinion for the court doesn't really help us out much, I guess, right? I mean, that's one of the things that was a little frustrating from my perspective, was he's talking a lot more about what he's not deciding than even giving you sort of a guide for going forward.
When the opinion came down and I saw Gorsuch had the majority, at first I was a little bit excited because if you remember, argument, he more than any other justice was sort of focused in on the statutory phrase unlawful user. He also, in other cases, has focused on vagueness issues and really been a champion for the void for vagueness doctrine and the rule of lenity. But then when I started reading it, as you said, it's a pure Second Amendment as applied, very narrow decision. And so it's sort of puzzling. I think the likeliest explanation, speculating a bit here, is that he's writing for the court here, right? Not for himself. So in a lot of the opinions where he advances a robust rule of lenity or void for vagueness doctrine or constitutional avoidance in light of vagueness, he's writing just for himself, maybe one other justice. And so it may be that the need to keep a majority sort of kept him focused on the Second Amendment issue here.
History was a big part of Justice Gorsuch's opinion for the court. Maybe it's easier to get 6 votes when you're talking history than actual doctrine. Interested to sort of hear your take, Jake, on, how that history found expression in the court's latest iteration of Second Amendment doctrine and whether that's going to be an important part of both defendants trying to take Hemani beyond just Hemani's case itself, and do we have even a broader view of the court's take on this history as it build into modern Second Amendment doctrine?
Yeah, I think we have some hints from the majority's opinion here about how they're going to treat the historical record, and in particular, how they're going to treat some of the purposes behind 922G3. So the court here repeats something it had said in Bruen, that it is going to decide the cases based on the record that the parties have compiled. And there's some debate in lower courts about whether that means courts are restricted to that record or whether they're just allowed to decide based on that record. And I think you could read the majority decision either way here, but it focuses only on the laws the government cited in support, and that was this trio of laws that were essentially getting at habitual drunkards. And the court distinguishes those laws from the modern law on a number of different grounds that it has made relevant in its Bruen and post-Bruen cases, why those laws are disarming particular people and how they're going about disarming particular people. The historical laws the government cites weren't really about keeping guns away from dangerous people. They were about different kinds of things, sometimes maybe about public safety, but more often about a person's individual safety, someone who couldn't take care of themselves or their family, those kind of concerns. Now, one thing the court said about the purposes behind 922G3 might actually have a broader effect. It said 2 things that kind of distinguish this case. One is something that some of the justices had echoed at oral argument, which is it's not clear that G3's incorporation of the Controlled Substances Act as the ground of what makes somebody a non-lawful drug user necessarily entails judgments about dangerousness. The Controlled Substances Act was designed for a whole bunch of reasons, health and safety, and it's not clear that every drug that's listed on the schedules is a drug that would make somebody dangerous, or that Congress even thought that. But also it points to the particular federal treatment of marijuana, the changing in scheduling for particular kinds of marijuana, the decrease in federal resources for prosecution, the toleration of many statewide legalization regimes. And so if the court follows that line of reasoning, then you might think marijuana is different. If the court follows the former, then you might think that Congress needs to do something more than just cross-reference the Controlled Substances Act in order to get some kind of court deference on its judgments about who is dangerous when they're under the influence or possessing firearms.
So the law nerd in me wants to particularly jump in here and talk a little bit more about the court's reference to recent state and federal developments with respect to marijuana law and policy. I thought we were doing originalism, or at least I'm trying to understand where that fits into a broader set of conversations. We'd maybe have to go back to the 30s, not so much the 70s, to say there was a time in our recent history where we thought people who use marijuana were the most dangerous people. But I'm wondering, is there a basis for somebody who comes at this with an open-mindedness but uncertainty about how originalism works, as we don't disavow all that old law, but it seems like an awful lot of new developments matter to taking stock and giving constitutional significance to prior enactments?
I share your skepticism about originalism as a theory or methodology, and not wanting to defend it too much, but maybe just to defend some parts of the court's opinion in this case. What I think the court would say, at least the originalist justices would say, for why it's permissible to think about those changes now is that the Bruen test is asking for some kind of analogous similarity between the historical laws and the laws at issue today. And it lists these metrics upon which we're to consider them. And one of those is about the reasons for why the contemporary laws are being enacted. And so if we are asking why the contemporary law is on the books still, or what the legislature has had in mind, then that is going to require some kind of consideration about what we're doing today. Then that has to map onto something that was happening in history. And the kind of historical reasons shouldn't change, but the modern reasons why we're enacting a law, I think those are relevant even under a Bruen methodology. And the court says at one point in its opinion, it says, we appreciate that the government's effort to analogize a modern statute addressing drug use to historical laws must be approached with sensitivity to the fact that many drugs well known today were unknown in early America. So it's recognizing this kind of analogical leap that it has to do. I think it presents a whole bunch of additional problems of doing that analogical leap, but I don't think it's necessarily inconsistent with originalism to say, the changes in how we're regulating marijuana today give us hesitation in thinking about what the purposes are under 922G3.
I agree with that. And I would just add that Justice Alito's concurrence that Kagan joined basically says, look, at bottom, the historical evidence that's been presented to the court says you have to be incapacitated, that the drunkard laws were about being incapacitated and disarming folks that were incapacitated. The evidence here for Hemani doesn't reach that level. And I think that's sort of a clear example of what Jake's getting at. It sounds like whatever the parties present as the history, right, to sort of fix whatever we think the constitutional rule is. And then in any given application, evidence may be different. And to your point, Doug, back in the 30s, maybe there was evidence or really assumptions or flawed assumptions that marijuana was very dangerous, and we have better evidence now suggesting that's not the case. And so it could be a fixed rule in theory, but just a different application based on new evidence.
Well, speaking of concurring opinions, so Justice Jackson's concurrence essentially argued that the court keeps conducting means end analysis while pretending not to. So for listeners not totally familiar with what means end analysis is, can one of you explain maybe what she meant and then tell us whether you think that criticism is fair?
Means in analysis is sort of the traditional way that the court has interpreted or implemented constitutional rights, usually by doing something like strict or intermediate scrutiny, where the court is asking about what is the government's interest in regulating? Is it a compelling? Is it important? Is it a substantial interest? And then is the law tailored to that interest? Is it narrowly tailored under strict scrutiny? Is there a substantial fit between the means and the ends under intermediate scrutiny? So that form of means and scrutiny is what lower courts had used for more than a decade prior to the Bruen decision. Bruen said that was an illegitimate mode of doing constitutional law, didn't disrupt it for other areas where the court still conducts that form of inquiry, but it said you can't do it for the Second Amendment. What Jackson's critique is that by asking about the how and the why, those are essentially means and ends questions. The why is, what are you regulating for? What is the end for which you're regulating? Public safety, often the end of a lot of gun laws. And then the how is the means. How are you regulating? How are you burdening particular conduct? I think the critique, if you want to call it a critique, has a lot of bite. I think it's correct that what the court is doing in a lot of these cases, I think we see it in Rahimi, I think we see it here, is that the court is essentially asking, is there two lacks of a fit between the way that the law is regulating and what it's actually trying to do? What the majority, what the Bruen adherents would say in response is that they're not doing the form of means and scrutiny that they discarded. Instead, they're trying to ensure that that same kind of means and fit is happening with the modern laws. I'm not sure there's much daylight between what they rejected and what they're actually doing them.
I thought the other thing that was interesting about the Jackson concurrence is she sort of highlighted this point that I think anyone that's paying attention to the lower courts is seeing, that lower courts are all over the place in applying Bruen right now. And it seems really unpredictable from the perspective of citizens or, particular defendants in these criminal cases as to which way a particular court or particular judge is going to go. And it doesn't seem more principled or more predictable than the old means end scrutiny.
Given the makeup of this court, is there something about originalism and historical precedents versus means end analysis that they would be posturing a decision as historical precedent or originalism and not means and analysis, and Jackson is calling them out. It's just an interesting kind of like poke. Is she poking?
So she's definitely poking.
I'll say that something in theory incompatible with being an originalist and thinking that the implementing test should still be means and scrutiny, but as a contingent matter of our constitutional history in the last couple of decades, means and scrutiny has tended to be the methodology, at least in the Second Amendment cases, that has become a target for originalists and conservatives who think that it allows judges too much discretion to uphold gun laws.
I definitely think there are certain justices on the court that are keen to not just distance themselves from originalism, but to criticize those claiming to be originalists for doing the same thing under a different cloak, and then also using that as a mechanism to get to preferred results in a different way without kind of owning it as a commitment to a particular judicial philosophy. But I actually want to jump in with whether you think other branches not just have a role to play, but will take up a potential role in the post-Hemani period. We talked a little bit earlier about, I think, a very righteous concern. We're just going to get litigation over other drugs and other uses of other drugs and gun possession going forward because courts can't avoid these issues in the context of actual prosecutions. But I wonder if you've given some thought or have some reason to be, if not hopeful, at least intrigued by the possibility that the other branches will respond in a way that could be helpful in this setting?
I think that there is a chance that the executive branch is definitely going to respond, I think, incentive-wise to these kind of cases in not bringing occasional marijuana user cases anymore, unless it can have a strong foundation for thinking that the person that it's prosecuting is separate from Mr. Hemani. I think it'll probably also incentivize just adding additional charges on in case these ones get dismissed or in case it can't later develop that kind of evidence that courts are looking for. I don't suspect that Congress is going to do much, especially in response to this ruling, at least with respect to G3. It might change marijuana scheduling, and that might have follow-on effects, but I'm not sure that I could see it changing G3. There has been, for more than a decade, a circuit split over the constitutionality of the felon prohibitor, and Congress has done nothing at all to change the scope of that.
I don't think there's much chance Congress will do anything in light of Hemani. But I do think this will, at least at a minimum, sort of change behavior on the ground of prosecutors. For one thing, maybe prosecutors will start trying to use the addict prong more under this statute. My understanding is they haven't needed to because there was such a broad conception of the unlawful user prong. They've just always sort of pinned prosecutions to that textual hook. But separate from that, the government's going to have to pull up its socks a little bit on building a record of drug use in particular cases and maybe dangerousness too, right? I think they've been pretty lax in just getting one or two pieces of evidence of possession or use for these prosecutions. And so I think that's a good thing, right? It'll force them to do more work and to actually generate more evidence when they do want to bring these cases. And like Jake said, I think there will be fewer of these cases.
And just one kind of data point for that, illustrating both the uncertainty after Hemani and how the prosecutors might respond on the ground, is that just a week ago, or even less than a week ago, and we're recording here in mid-July, the Eighth Circuit upheld a 922G3 prosecution against a marijuana user, notwithstanding Hemani. And in that case, same drug, similar evidence of usage, but not necessarily usage at the time of possession, although there was a blood test that was done on this man. The case is United States versus Baxter. But in that case, there was what the Eighth Circuit called a post-trial dangerousness hearing, at which the judge went through a whole bunch of evidence about the underlying circumstances that gave rise to the prosecution, about the criminal history of the person. It entertained expert testimony from a toxicologist about how chronic marijuana use can lead to aggressiveness. And so in that case, because there was a lot of additional evidence beyond just the fact that the person was an occasional marijuana user, the court felt comfortable upholding it and rejecting the Second Amendment challenge. And I think we might see more of that. I think that's a real problem. If you look at the end of the Hemani decision, Justice Gorsuch lists 7 areas, specific questions in which it says, we do not address these questions about the scope of this particular law in the G1 law about drug convictions. And that's a real problem because it means that courts are going to be developing these one challenge at a time. And for many people who might be gun owners, it's going to leave them in a place of uncertainty about the application of the law that they're not going to find out until long after the fact when a court is applying a standard that it's developing maybe on the spot.
Yeah, I saw that Eighth Circuit opinion. I was intrigued by it. It led me to think that lower courts, and certainly I assume the federal government in prosecution, will argue if you're not clearly a Hemani, essentially, or a Hemani analog, then that's not covered by the Second Amendment. This becomes for lower courts an easy out for, hey, here's a fact that's different than Hemani's fact, good enough for us, presumption of constitutionality or some variation on that theme. Coupled with, and I think this is your point, Joel, that the government is going to have a reason to put in the record whatever facts it thinks makes this a stronger case. And my instinct vis-a-vis 922 G3 prosecutions for a long time, the government hasn't built that record, not because it isn't possible that it's there, but they haven't had to until now make a stronger record. And so I just would, again, kind of like your take on, could this be the end in some respects of sort of significant jurisprudence in the drug space, at least, a kind of blueprint for the government to make sure they can put facts in the record that distinguish the new case from Hemani, and everyone goes home happy saying that that's consistent with the Second Amendment?
I think that's a fair reading of what happened, right, with the decision here. And I would tie this, though, to things outside of the drug context and outside of the Second Amendment context. This is, in my view, kind of what the Roberts Court in the last at least 5 to 6 years is doing in criminal cases. It decides issues very, very narrowly, almost case specific. And so sometimes it'll give relief to the defendant, but it's really just that defendant or a few people that happen to be very closely situated. And it sends sort of this indirect signal in the way you were describing to lower courts, here's the path, or to the government, here's the path to avoid reversal in the future. And I think that reflects just a general comfort on the part of the Roberts Court with the status quo of the criminal justice system, for better or worse. But it's been a frustration of mine as someone who tracks across areas in the criminal context. You'll get these big grants, and very rarely are there large-scale decisions.
So let's bring it back to Second Amendment and gun possession. Supreme Court watchers expected them to pair Hemani with the Hawaii case. Both of the decisions are out there. So what are your biggest takeaways about how this court might be approaching gun rights?
Yeah, I think that was the initial presumption of many people. They never taken 2 Second Amendment cases in a single term before. And the thinking was, hey, a drug user with guns, that'll be easy for the Roberts courts to uphold. Hawaii regulating guns, that'll be easy for the Roberts courts to strike down. When the actual facts and the legal theories were developed, I think some of us, like Joel and I, said last time, it seems like they were going to strike down both laws. And that's what they ended up doing. Here on incredibly narrow grounds in Hemani that leave open a lot of additional regulatory authority, including, the way I read the opinion, categorical judgments that certain categories of people can be disarmed as so long as there is a sufficient justification for that. In the Wolford case, the court went a lot farther in Second Amendment methodology than it went in the Hemani case. On that case, Justice Gorsuch is writing for 6 other justices, including Justice Sotomayor and Justice Jackson. In the Wolford case, it's an opinion by Justice Alito that is split on ideological lines. Justice Alito writing for the 5 other conservative, Republican-appointed justices, and the dissenting justices are the left-leaning justices. In the Wolford case, the court, I think, erected an even higher barrier to gun regulations. And part of that, I think, is Justice Alito's real antipathy toward blue states regulating guns restrictively.
I think Wolford didn't cite Hemani, or at least didn't reference it. I'm not enough of a Supreme Court nerd to even know for sure if that means they expected to get Wolford out first, or they expected to have him out together, that Justice Gorsuch wrote faster than Justice Alito. But they didn't seem to be talking to each other much, I guess. And I suppose that's not that surprising for exactly the reasons you suggested, Jake. Maybe Hemani is much more like a criminal law case, where we're just talking about one particular defendant having one very narrow path to claiming a right that prevents his prosecution. My understanding is they've granted cert on an assault weapon bans case, or I may not even be describing it right. And so I guess more than eager to be the first ones to get you all on record, even before we've seen briefing and argument. Is that one going to be a big one and tell us a lot in this space? And then I especially want to get to the felon in possession question. Suppose you have a felony record based on marijuana use and possession. Does Hemani cover that or not? Or is it a different equation? Because once you've been convicted of it, somehow you're potentially categorically more dangerous than if you haven't been convicted of it or something along those lines. It seems the court going out of its way to avoid the potentially much more consequential issue, at least in terms of federal prosecution, of felon in possession bans.
Yeah, the court granted for next term and consolidated a challenge to assault weapon bans in Cook County that came out of the Seventh Circuit and one in Connecticut that came out of the Second Circuit. Those cases are going to be absolutely monumental. The assault weapons issue, I think, polarizes and is a matter of public discussion far more than even marijuana, even though marijuana is a big issue of public discussion. But I think those cases are going to be huge. I don't have any good predictions yet on them. The briefings are not going to be due until October in those cases. And I think it's noteworthy that these cases happened before Bruen, where courts were upholding, and I should say, the circuit courts are unanimous in upholding assault weapon bans against Second Amendment challenge. This is not a case where the court took it because there was a circuit split. The circuit courts are agreeing these are constitutional, and the court took the case nonetheless. So you might read into some tea leaves there.
And I'll say on the felon in possession cases, which was just a mess in the lower courts, it's sort of interesting. This Hemani decision went out of its way to sort of say nothing we're saying here affects that litigation or 922G1. I think it's footnote 6 that does that expressly. But on the other hand, and Doug, you're sort of getting at this with your question, like just the majority's refusal to let the government kind of just declare this huge class of people as categorically dangerous. That closely relates to the as-applied challenges that non-violent felons have been bringing to the felon in possession ban. So in other words, I guess there's a way to view this where Hemani kind of tees up this new form of argument for someone maybe like a marijuana trafficker, right, who could now argue that if, millions of current casual marijuana users aren't categorically dangerous under 922G3, then an old conviction for distributing that substance, marijuana, doesn't prove the dangerousness, right, that would maybe be needed to justify lifetime disarmament. So you might see arguments pull in Hemani sort of in that indirect way. It's just worth highlighting, and this is something Jake and I have been talking about more recently, that the felon in possession mess in the lower courts is really a different type of problem than the one that Hemani teed up. From my perspective, the problem with G3 really is that unlawful user language, that vague language. But one advantage of that from the perspective of courts is that does give courts the ability to construe it, right? Because it's indeterminate, you can come up with a judicial construction. The text of the felon in possession ban is about as clear as a criminal statute can get. If you've been convicted of a crime punishable by more than a year, you can't possess a gun. And so any felon in theory could read that prohibition and know that it covers him. But with the way Bruen works, they can't really know in advance whether the prosecution would be constitutionally permitted. And there's all these different approaches in the lower courts, and even within particular circuits, there's disagreement among panels. And so there's kind of this big notice problem from the perspective of individuals who want to possess guns. This relates and maybe runs up against this deeply held principle in the criminal law context, which is often called the principle of legality, which is that in the federal court system, at least, federal courts are not allowed to define or create common law crimes. Like, it has to be the legislature that says what a crime is and is not. And is there a way in which this Bruen regime is sort of functionally making it the case that the courts case by case are saying this is a crime and this is not within the 922G1 setting?
I guess the sentence that caught my eye the most thinking about the felon in possessions issue, Justice Gorsuch's opinion for the court, cites to a former Judge Barrett dissent in a case out of the Seventh Circuit that I believe was a nonviolent felon in possession challenge, and she wanted to rule in his favor and the majority of the panel didn't. And I particularly thought, reading from the court now, affording the government that kind of broad power to designate any group as dangerous and therefore disqualify its members from having a gun would risk allowing it to quickly swallow the Second Amendment. It's another variation of why I brought up even the marijuana history. Probably disarming felons at the founding was a much, much smaller class of individuals because we just didn't have the mass prosecution realities, mass criminalization that define our modern justice systems. Am I overreading tea leaves that some of the justices want to drop Easter eggs to let them have an argument to at least strike down some aspect of felon in possession?
No, I think you're right. And her dissent there has been really influential in the lower courts, where a lot of judges are citing it to say, hey, look, someone who plays a pivotal role in the court now thinks that these laws are unconstitutional on at least some of their applications. There's at least 3 and maybe more circuits that do allow as applied challenges. And they have found Justice Barrett's dangerousness principle to be the dividing line between those kind of people who can be permissibly disarmed under 922G1 and those who cannot. The problem, I think, for maybe why we're not seeing the court take a felon in possession case yet is that maybe there's not agreement on how to operationalize that principle, even if there's a majority for thinking that is the relevant principle. Because the circuit splits on this very question have been reaching the court for over a decade, and there hasn't been even 4 votes in favor of granting cert on one of them.
I'll tether this back to Joel's bailiwick in that to the extent the justices don't like something, it's having to try to define violence for purposes of the Armed Career Criminal Act, which led to, among other things, a leading vagueness ruling some years back. And I suspect on legality principles, trying to give effect to that as doctrine will prove not just challenging to the entire system, but especially to the Supreme Court. And I know they got tired of taking ACCA cases. That's the cases that they had to sort of figure out what this is. And for those, in some respects, to come back under a different guise likely is not their vision of how they're going to take their summers off. But I get snarky because I kind of think it's their job to do this. And the fact that they don't want to is not a good reason not to.
I totally agree with you on it is their job, even if it's uncomfortable. It's not like the ACCA cases where the problem was Congress's drafting of the statute. The problem here is the court's own making in Bruen. I mean, the felon in possession statute is the most charged federal gun law. Tens of thousands of people are in prison because of this charge, and the court's failure to resolve that and to offer more guidance, I think, is really not a good thing.
Also, this court, I think, really wants to retain discretion for itself in future cases. And so I see that as like the driving principle in a lot of these cases where it wants to wait till the next case to actually say its piece on that specific issue. And I sort of see that there's a judicial minimalism argument for that, and there's some virtues to that. But I think like in a context like this, the lower courts are totally at sea right now for the reasons Jake said.
Sort of interesting. I haven't heard nearly as much post-Hemani discourse as I would have expected. Now, part of that's because we're talking about birthright citizenship and we're talking about this and that and these and those.
Do you feel like there hasn't been a lot of chatter because A, the court didn't really say anything like groundbreaking, and B, anything they would say would likely have to effectively be a criticism of the fact that the court hasn't really cleared anything up?
The lower court in Hemani had already said his conviction violated the Second Amendment. So the court, if it was just going to say nothing else besides what it said, didn't need to take a case at all.
That's a great point. Yeah, this was an affirmance. Yeah. You would expect more from a court that only takes 60 or so merits cases a year.
Well, Joel, Jake, thanks for joining us today and taking the time to discuss Hemani.
Second those thanks. Such a joy for me to get to talk through some of these matters and start to piece out where we're headed. I think we're going to all be in it together trying to puzzle it out until the court gives us some more answers.
Yeah, thank you so much. This was a lot of fun.
Great discussion. Thank you.
Drugs on the Docket is a production of the Moritz College of Law, Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.